because all of them have been working as part of the African group, and their voice has been very influential in the negotiations. Also, thanks to the advice that we have been providing to them. And so I framed my presentation into about 3 key research questions, which I would like to elaborate on. One of them is, should African states apply for contracts or sponsor contractors for seabed mining in the area? And I'm assuming that the presentation given by Professor Nabulele has laid the groundwork, the foundation, for me to not go back into some of those basic ideas around seabed mining exploration at the area. So I'm assuming that he has laid adequate foundation for me to build on it without going back to some of those basic ideas. So the second key question is, what are the pros and cons of African states applying for contracts or sponsoring contractors at the ISA? And what are the key issues that African states should consider when developing their own national legislation to participate in seabed mineral activities in the area? First of all, let me give a brief overview of Africa and seabed mining, because it's an aspect that has not been much talked about. Seabed mining, prospecting and exploration has been going on in Africa for quite some time. Within national jurisdiction, 2 countries stand out in this area, and they are Namibia and South Africa. In Namibia, marine diamonds exploration has been going on since the early 1990s, whereas in South Africa, exploration for manganese and phosphates has been going on since the 2000s. But for this presentation, my primary focus is not national jurisdiction, but seabed mining in areas beyond national jurisdiction, which Professor Nabulele explained very clearly. I think in around 1988, yes, around 1988, African states have for a long time recognized the economic importance of seabed mining for the continent as far back as 1988 in the Kampala Program of Action on the Development and Utilization of Mineral Resources in Africa. The program saw seabed mining as a possible future alternative source of nickel, copper, manganese, cobalt, and other minerals that are produced in land-based mining operations. However, for about 3 decades after the Kampala Program of Action, there was no further supranational level discussion of seabed mining in Africa, despite the adoption of the 2050 Africa's Integrated Maritime Strategy in 2014. The maritime strategy provides a broad policy and institutional framework for the sustainable exploitation of Africa's seas and oceans. Yet, it largely ignored the importance of seabed mining as a blue economy sector. However, the African Union Agenda 2063, which was launched in the same year as the maritime strategy was launched, recognized seabed mining as a potential blue economy activity. And the goal was set to commission and complete seabed mining prospecting in Africa by 2023. That year has since passed, and practically nothing has been done, let alone completing seabed mining prospecting in the continent. In 2017, a workshop was organized in Kampala by the African Mineral Development Center and a number of its partners, which included the UNECA, UN Economic Commission for Africa, to raise the interest of African states in the development of mineral resources in Africa's continental shelf and the adjacent international seabed area. In this workshop, they talked about capacity building of African states to engage in seabed mining in the area. In 2018, UNECA argued that it was in the strategic interest of Africa to join other states in participating in seabed mining in the area. And the 2019 African Blue Economy Strategy boldly recognizes the importance of seabed mining to Africa's economic transformation. ABS, which is the Blue Economic Strategy, anticipated that seabed mining in Africa's EEZ could contribute up to 76 billion US dollars by 2030 and 123 billion US dollars by 2063 to Africa's economy. Despite extensively discussing seabed mining, however, ABS is completely silent about Africa's participation in seabed mining in the area. So its main focus was on seabed mining within Africa's national jurisdiction. So that provides a context of seabed mining in Africa, especially with regard to Africa's involvement in activities in the area. But of course, with the negotiations that have been going on for so many years now, exploration regulations were passed around 2013, and since then, exploitation regulations are still being negotiated. And we hope that by summer this year, they will be able to come to an agreement and adopt some documents. Though some have said that it's not looking quite likely to happen, but we'll see what happens. So I will speak a little bit about participation in seabed mining in the area, although Professor Nabulele laid some context, but I think I need some details in order to ground further discussion. So the area, as he explained, is that part of the ocean that is beyond the limits of national jurisdiction. It has a status of the common heritage of mankind, so it belongs to all of us. It's also subject to the UNCLOS legal regime, so it's regulated by the UN Convention on the Law of the Sea, and also the institution that actually carries out the implementation of UNCLOS is the International Seabed Authority, which is headquartered in Jamaica. Participation in activities in the area is through contracts that are issued by the International Seabed Authority. These contracts can be issued directly to a state party to UNCLOS, or contracts, it can also be issued to enterprises, natural or juridical persons that are sponsored by state parties to UNCLOS. In the ISA, they have what they call the enterprise, which is more like a business entity that is owned by the ISA. Is going to get involved in seabed mining activities, pretty much like a private entity. So the enterprise can also be awarded a contract. It is an organ is akin to an organ of the ISA. So it's like an ISA-owned contractor or an ISA-owned company, just like you could have a state-owned company. However, the operationalization of the enterprise has not yet been completed. So it's still ongoing. There's been calls to fully operationalize it, but that has not yet happened. I think someone has been appointed, Eden Charles, to lead affairs in that aspect, but it has not, it does not hold any contract at the moment. Now, non-state parties are not eligible to sponsor contractors. Fortunately, there are not many non-state parties. I think foremost among them is the United States. So they are not eligible to sponsor a contractor to apply for contracts to the ISA. Typically, exploration contracts are for 15 years. They are granted for 15 years, but they can also be extended for periods not exceeding 5 years at a time. There is no actual exploitation going on right now because the exploitation regulations have not been fully negotiated and adopted. So all activities in the area are exploration, not exploitation. Now, who can be sponsored for a contract? The first is state entities themselves. So a state can put itself forward in its name to obtain a contract from the ISA. Natural persons or juridical persons that possess the nationality of state parties or that are effectively controlled by them or their nationals. This point is very loaded. And I don't think there's time to go into details of exactly what effective control means. It's a concept that continues to evolve. There's no consensus on exactly what it means for a state to have effective control of an entity that it is sponsoring. It's unclear whether it is limited to having legal control, whether it includes having other forms of control like financial control and others, and regulatory control. There are a number of recommended measures that a state should take in order to gain effective control over an entity. One of them is to enact a sponsorship law, so enact legislation that governs sponsorship of contractors. So the sponsorship law will hold contractors to compliance with the UNCLOS regime, which includes the rules and procedures of the ISA. The sponsorship law will also set domestic sanctions for non-compliance with that UNCLOS regime. Another measure that a state can take is to provide greater detail, really more stringent standards in its own national law for a contractor's liability obligations than are currently provided under UNCLOS. The reason for this is that the state may be liable for its negligence in controlling, in regulating its sponsored entity. So one measure a state may take would be to enact more stringent regulations than are currently in UNCLOS. Another measure a state may take would be to ensure that there are clear and accessible legal and judicial processes within its own jurisdiction for any claimant against a contractor, indicating causes of action and remedies that are available within its own domestic domain. A state can also consider using indemnities in the event of state liability to protect itself from liability, because a state can be roped in by the acts of the contractor if the state is shown to have neglected its due diligence obligation towards the contractor. A state may also consider requiring insurance and or some form of financial security from a contractor on terms that would enable the use of those mechanisms to cover costs that may arise against a state. Now, the next core issue has to do with the responsibility of sponsoring states, because it's not enough to sponsor. When you sponsor, you incur liability or responsibility. Under UNCLOS Article 139, a state has a responsibility to ensure that the sponsored contractor conducts the Seabed minimum activities in a manner that complies or conforms with UNCLOS provisions, or if the state neglects to do that, it may face liability for any harm that is caused by the actions of the contractor. The Seabed Disputes Chamber of the International Tribunal for the Law of the Sea issued an advisory opinion in 2011 to elaborate a little bit on what this responsibility means. And the tribunal indicated that it is a responsibility, it's not a responsibility to achieve the results that the sponsored contractor complies with UNCLOS. Rather, it is more like a responsibility of due diligence. So as long as the state shows that it was diligent in regulating the contractor, ensuring that it complied with UNCLOS and other applicable rules and regulations, that satisfies this responsibility requirement. Even if harm eventually occurs, the state will not be roped in. And for liability to be activated, there has to be a causal link between the damage and the activities of the contractor. So there has to be a link between the two. So far, there are about 31 exploration contracts that have been issued to about 20 states or their sponsored contractors. The states include Belgium, Brazil, Bulgaria, China, the Cook Islands, and others. Of these countries, 17 of them are in the Asia-Pacific region. 7 are in Western European states, 4 are in Eastern Europe, 1 in Latin America. 1 is awarded to a consortium of states that comprise 5 Eastern European states and Cuba. 1 to a Caribbean state, which is Jamaica. And to date, there is no single African country that sponsors any contractor at the ISA. Some people have said that the absence of an African state sponsoring a contractor is both surprising and disappointing. The reason for this disappointment is that 47 African states have ratified UNCLOS, and Africa has played very key role in the negotiation of the exploration and exploitation regulations. So why is Africa not sponsoring a contractor? First of all, the case against an African sponsoring state. Number one, participation in seabed mineral activities in the area is likely to be less profitable than seabed mining within national jurisdiction. The reason is that the International Seabed Authority will share in the economic benefits of seabed mining in the area, whereas within national jurisdiction, everything belongs to the state. And so it's purely between the state and the company that it grants a license. Whereas in the area, there are more or less three parties: the ISA, the states, and the contractor. So the economic benefits are likely to be less in the area than within national jurisdiction. The second point is that sponsoring states generally are in a weak negotiation position compared to contractors. The reason is that contractors can shop for states that offer more favorable deals. Remember, the resources do not belong to the states, they belong to all mankind. And so individual states don't really have that high bargaining power when it comes to negotiating the terms of the contract. They are more or less cabined by UNCLOS. So the application of their own domestic laws is very limited in the relationship between the states and the contractor. So there's likely to be what has been called sponsor shopping by contractors. Another one is sponsorship also comes with some costs, particularly costs that are related to potential liability to the ISA if damage results from the activities of the sponsored contractor. And then there is potential negative impact on revenues from land-based mining. The argument has been made that if mining begins in the area, perhaps it will lead to perhaps excessive supply of the minerals in the market, which may bring commodity prices down, thereby affecting minerals from land-based mining. And most African states, what they do is land-based mining, not seabed mining. So that is also another negative aspect of helping to develop activities in the area. Last but not least, there is lack of technological, institutional, financial, and governance capacities to participate effectively in seabed mining in the area. Remember, these activities take place distances away from the territory of the state. So there is very little oversight, and not just distances away, right deep into the sea, where many states do not have the technological capacity to go in and monitor the contractors. So the states rely mostly on what the contractors tell them that is happening there. Whether the contractors are telling the truth or not, nobody can really say. So that is also another disadvantage of sponsoring, because when you sponsor a contractor that you can site over, it becomes difficult for you to monitor. And that comes with a lot of risks. Now, the case for an African sponsoring state, it's been argued that by UNECA that it is in the strategic interest of Africa to join other states in participating in the activities of the international seabed area. Number one, participation might contribute to government revenue through taxes or royalties. No matter how small the revenues are, it's still a contribution, even though land-based mining may be more, or seabed mining within their EEZ may be more. But the one coming from the area is still a contribution, and it could still be significant, despite being less than what they will get within their national jurisdiction. There may also be contributions through job creation, technology transfer, and capacity building. And the Pacific Small Island developing states have been sponsoring contractors, despite not having the requisite institutional, financial, and governance capacities. If they can do that, Africans can also do that. They are not more technologically advanced, financially, economically, they are even worse off. They are more vulnerable to natural disasters. They have very small land area. little human resource capacity exists in those countries. So if they can do that, African states can equally do that. UNECA has made another point by saying that strategically speaking, Africa cannot afford to be left behind while the other regions of the world have forged ahead in acquiring technology and are positioned for the eventual commercial exploitation of the area. And so the argument is made, it is of strategic importance to Africa to enter into the arena of sponsorship. Now, I want to provide some general thoughts on African participation in this in seabed mining in the area, especially with some of the advantages and disadvantages that have been highlighted. They are not exactly as they look. For instance, contributions to job creation and technology transfer may not be significant, despite what people have said. Due to the highly specialized nature of seabed mining, a contractor's employees are likely to be mainly non-nationals of the sponsoring African states, because it will have to be people with the expertise. And because seabed mining is currently not going on in Africa and anywhere else, it will actually be difficult to find people with the specialized skills needed. And where they are to be found, they are likely to be found outside African states. And so the promises of job creation may not materialize to the extent that it has been promised. The other one is local procurement of goods and services, which is an important capacity building instrument. It is also likely to be minimal because sponsoring African states may lack the capacity to deliver the goods and services that are required. The kind of technicians they need, the kind of professional services they will need may not be available within African states. One option is for African states to hold off until the exploitation regulations are concluded. That is one option African states can consider. The reason for this is that the lack of an African sponsoring state has allowed Africa to speak with one voice. Because the moment one African state sponsors a contractor, its interest in activities in the area is now well defined and may no longer align with the interests of the whole of Africa. So some people have suggested that Africa may have to hold on. Let's conclude the exploitation regulations, and then we can begin to sponsor. In any event, the decision to sponsor would be that of the individual African states to make. Yeah. One of the key aspects of this is the need to enact domestic legislation. And what I have done here is to identify some of the key issues that an African state interested in sponsoring a contractor should take into account when developing national legislation. One of them has to do with the sponsorship or contractual arrangements between the sponsoring state and the contractor. The other one would be the use of subcontractors to implement the ISA contract. The next would be the fiscal regime and then the institutional framework. There are different sponsorship or contractual arrangements that may exist between a sponsoring state and a contractor. One type of arrangement is where the state itself serves as the sole contractor. The state will apply for a contract in its own name, and in practical terms, we have to engage a third party to implement the contract because the state is not a mining company. So eventually it will have to subcontract that contract to a private entity with the expertise to execute the contract. One advantage of this is that the state may obtain a higher stake from the third party. So the state gets the contract, finds the mining company and hands it to him. So the state can negotiate the terms of such contracts with the contractor. In that arrangement, that contractor is not a sponsoring state. It's more like a subcontractor. Now, the disadvantage is that the state will bear the cost of obtaining the ISA contract. It's not free. So there is an application fee that has to be paid, a couple thousands of dollars. The state will also have to bear the cost of obtaining preliminary environmental assessments, which is a requirement for applying for a contract at the ISA. And the state is directly liable to the ISA for any non-compliance. So it's no longer a question of the state bearing responsibility to police the contractor. The state itself is the contractor. So it bears direct responsibility to the ISA. Another type of arrangement is where the state sponsors a state-owned enterprise. So the state issues a certificate of sponsorship to the state-owned enterprise, and the state-owned enterprise becomes the contractor and may implement the contract without a third party. So if the state-owned enterprise likes, it can still engage a third party to help implement the contract if it doesn't have the expertise. One advantage is that the state, the gains to the state-owned enterprise are the gains of the state itself, because the state owns the enterprise. The disadvantage is that losses to the state-owned enterprise become losses to the state. The third type of arrangement will be the state will sponsor a private entity to apply for a contract at the ISA. And so the state will issue a certificate of sponsorship to the private entity, and the private entity will approach the ISA and apply for the contract. One advantage is that the private entity will bear the costs of the ISA application, and the private entity is directly liable to the ISA. The state only has a responsibility to ensure obligation. Disadvantage, the state's bargaining power may be weak, because private entities may have to shop around for states that will offer more favorable sponsorship terms to them. And so the state may be in a weak bargaining power, which may result in low financial take from the sponsorship. The fourth arrangement is where a state sponsors a state enterprise and a private entity in a joint venture. And so the state will issue a certificate of sponsorship to the joint venture, not to one of them, because they will have to come together to form a JV. And so the contractor becomes the JV. Advantage, both state enterprise and private entity will bear the application costs. And then both of them are directly liable to the ISA for any damage that occurs. Disadvantage, the state bears both responsibility to ensure and partial direct responsibility if harm occurs. Partial direct responsibility because of the involvement of a state-owned enterprise. So any liability against the state-owned enterprise is actually that of the state. And so the state bears double responsibility here. And the fifth one, which is the last, will be where the state or private entity joins with the enterprise. Remember, the enterprise is like the business arm of the ISA. So the enterprise is allowed to enter into agreements with states or state-sponsored parties for a contract. So the arrangement may be in the form of a joint venture or production sharing or any other form of joint arrangement. Advantage, the extent of financial obligations of the state depends on the terms of the JV. So that is where everything will be spelled out. And then for disadvantages, the nature and extent of responsibility to be incurred by the enterprise has not yet been fully clarified. And so nobody knows what extent of liability the state may be subject to. The enterprise is still evolving. The rules governing it have not yet been fleshed out. In fact, it has not been operationalized. Now, the other one is that where the JV is between the enterprise and the state-sponsored enterprise, the state's responsibility to ensure remains. However, it remains towards the state-owned enterprise that is sponsored, not towards the enterprise itself, because the enterprise is not under the jurisdiction of the state. The use of subcontractors requires some closer attention. There is nothing in UNCLOS or in the ISA regulations or rules and procedures that prohibits the use of subcontractors. So a sponsored party can actually subcontract. However, it will most likely be with the consent of the sponsoring state. Now, the activities of a subcontractor are attributed to the contractor, and sponsoring state obligations remain, even where the contract has been subcontracted to a third party. So there is the risk of exposure to liability for the sponsoring state is heightened where a subcontractor is used, because the liability to ISA does not whittle down just because a subcontractor has been used. There has been a case that is bringing a lot of headache in Kiribati in the Pacific Islands, where the sponsored party is a state-owned enterprise, Marwa, and then it's subcontracted to Deep Green, which is a private entity. The relationship between them has been a bit complex, and it is unclear what would happen, assuming Deep Green conducts the activities in a manner that unlawfully damages things that may incur liability. So that's when states think of using subcontractor, they have to be very careful to choose the right subcontractor, because they remain liable, especially when the sponsored party is a state-owned enterprise. And so one way to deal with this is for national legislation to include stringent measures for the approval of subcontractors, to make sure that the subcontractor that is approved is a fit and proper person to be awarded an ISA contract. Now, a little bit about the institutional framework, which is also very critical, especially in terms of minimizing a state's liability or exposure to liability. Every state needs to establish a national institutional framework to enforce compliance with ISA contracts. In many cases, it would be the mining ministry or some other entity, depending on how the state is organized. There is need to streamline regulatory authority, because seabed mining is quite new, even to governmental institutions. They may not fully understand it. So there is need to streamline regulatory authority within the country to ensure that contractors are properly regulated. Seabed mining may raise so many issues that may affect multiple regulatory agencies within the country. So there is need for them to take a whole of government approach to ensure that the activities are adequately regulated. There are not many experts, including legal experts, and as well as economists on seabed mining around the world. There are very few of them, and the reason is that seabed mining doesn't yet actually occur. What is happening at this stage is exploration. Mining hasn't actually started. Revenues haven't actually started coming. So there are very few legal experts and economists who have expertise in seabed mining around the world. So that poses a challenge in terms of having the right institutions with the right expertise to run those institutions with regard to seabed mining. Now, a little bit about the fiscal regime, because any national sponsorship regulation also has to address the fiscal regime. Contractors are in a strong position to negotiate corporate income tax exemptions. They are in a strong position because they can shop for sponsors in any country in the world, so long as that country is a member of, is a party to UNCLOS. And quite a few countries are not. So they have that leverage to go around the world and convince states to sponsor them. The sponsor state does not own the resources and doesn't have full control access to the resource. So their bargaining power is low. Another one is that profit tax will be subject to high transfer pricing risks. So because there is little oversight of what is happening at the seabed, even when they bring up the minerals, even when they bring them up, there is little oversight on the part of states. So issues like transfer pricing are likely to be rampant. Companies are going to use these things to minimize their tax burden. The other one is that currently it is difficult to gauge what a fair royalty for the sponsoring state is. There are no standard models or international comparisons to be made at this time. The main reason being that revenues haven't started coming. So this is something that will take time to evolve, and then the rules will become clearer and clearer as we go along. Um, the other one is that sponsorship revenue would likely exceed administrative costs. But for most countries, the revenues are not going to be a game changer. As I noted earlier, the revenues are likely to be less than revenues coming from seabed mining within national jurisdiction. The other point is that the target royalty rate should be the highest rate the contractor will bear without closing negotiations. So if a state sets its royalty rate very high, it's likely going to be a disincentive to contractors to come for sponsorship. So a state will have to navigate and perhaps look at what other jurisdictions that have sponsored contractors are doing in terms of their royalty rates. It's no longer a question of regional comparison, because the companies have the whole world to go to regardless of region. So making regional comparisons in terms of royalty rates may not be enough. You have to make international comparisons. Africans, we have to compare the rates in the Pacific region, because right now the Pacific region is ahead of all the regions in terms of the number of sponsorships that they have carried out. And last but not least, there is potentially a difficult to cost danger to African unity. Like I said earlier, right now that the negotiations are still going on, if an African state goes into sponsorship right now, it's likely going to bring disunity within the African group at the International Seabed Authority, because the interest of that single state that now sponsors will become different from that of the whole. So that is also one aspect that an African states will have to consider. And in conclusion, African states should be aware that sponsorship of a contractor comes with obligations. Those obligations, as have been noted by the international, by the tribunal, this settlement tribunal, it's an obligation of due diligence to ensure that the party that is sponsored carries out the seabed mining activities in compliance with all clause and the rules and regulations of the ISA, plus the terms of the ISA contract. Because when the contract is issued, it contains terms, so those terms will also have to be complied with. The obligations, the obligation, the responsibility to ensure is fulfilled or discharged using both domestic legal and administrative mechanisms, and failure to discharge them may incur serious liability for a state. The African states should also note that the framework that UNCLOS sets is the floor, it's not the ceiling. So they can enact more stringent measures, provided those stringent measures do not conflict with UNCLOS. And there's a lot of experience to be learned from sponsoring states, especially in other developing states, like in the Pacific, as well as in the Caribbean. At least Jamaica is there. So African states can also look to these other states that have sponsored to see what lessons they can learn from them. And finally, African states may cooperate with other states in raising the standards instead of merely eagerly participating in what may be a race to the bottom. So they can work together with other states in other regions, especially now that negotiations have not been concluded, to make sure that the standards are high in order to protect sponsoring states. Thank you very much for having me. I'll be happy to respond to any questions or comments that you may have.
Thank you so much, Dr. Chilenye Nwapi. Thank you for this eye-opening exposition on the blue economy seabed beyond national jurisdiction. So please, if you have any question, I didn't get any. If you have any question, please, you can indicate so that our resource persons can attend to your questions. If you have any question, please kindly indicate. Any question? Okay. Okay, we'll have a question here. Okay, so this question is from Mr. Orwell. He said he needs clarification on the following. So I'll take the question. The question is on the common heritage of mankind. Does the concept of common heritage of mankind include allocation of resources derived from the seabed, or is it strictly limited to mining and exploration of resources? If it includes resources, if it includes resource allocation after mining, how are the resources allocated to states, especially where one state secured the contract from ISA and solely engaged its contractors? So that is the first question, Dr. Chile.
Yes,
Then
I
the
have seen it. I can take it up and also take the second one. I'm looking at the screen. Yeah, I
okay.
think it's a very important question because the application of the common heritage of mankind principle is one that is now being debated when it comes to sharing the proceeds of the mining. The fiscal regime for the exploitation regulations is still being debated. It's a very complex one. A lot of proposals have been made. First of all, I'm not an economist, so I may not be as in-depth as you might expect. My knowledge of economics has come mostly from working with economists on this issue. Yeah. So what happens is that if a party is sponsored and then does exploration and proceeds to mining, the proceeds, the financial proceeds of that, they will pay taxes to the ISA. Yeah, the ISA represents all mankind. So they will pay taxes to the ISA. They will also pay some taxes to the sponsoring states, but the taxes they will pay to the sponsoring states will be based on contracts, based on what they and the sponsoring state agree. Whereas the taxes to the ISA will be stipulated in the regulations that are being negotiated. So that one is not a contract. So there's now an ongoing debate around how can the profits be shared to ensure that the common heritage of mankind principle is upheld. There is no definitive answer to that. But that is my response to your first question. So the fact that a state sponsors or puts itself forward for a contract does not mean that it takes the proceeds to itself. No, taxes will be paid to the ISA. So the states will have to pay taxes to the ISA. The rate of tax to be paid to the ISA will be fixed in the regulations that are being negotiated. So that has not yet been determined. And then when the ISA gets the money, the question is how should the ISA distribute it to make sure that all mankind benefits from it? That is also something that is evolving. There is no clear definitive answer as to how they're going to do that. Now to your second question, what are the applicable taxes for revenues derived from seabed mining and which body is tax remitted to? Well, the applicable taxes have not yet been determined. There have been many proposals that have been made. And of course, the companies themselves, the companies holding contracts are very interested. So they have also been doing their best to make sure that they influence what will be the final decision that will be adopted on the fiscal regime. So that has not yet been determined. However, the taxes will be remitted to the International Seabed Authority. So it is the agency, an arm of, it is the agency that represents all mankind. So they will be the recipients of the tax, and then they will manage the money in a way that is in compliance with the principle of common heritage of mankind.
Thank you so much, sir. Thank
Yeah.
you. Thank you for that. There's another question. I think, but I'll let you attend to that. I think.
Yes, I have seen it. A private contractor cannot on its own apply to the International Seabed Authority. It has to go through a state. So a private contractor will have to approach a state for sponsorship. If the state agrees, they enter into an agreement, and then the state will issue a certificate of sponsorship to the contractor. The contractor will then take the certificate of sponsorship and go to ISA and follow the rules and procedures of the ISA for applying for a contract. which would normally include a preliminary environmental impact assessment, and then, of course, a proposal of how it's going to carry out the exploration. The ISA will review the application and make a decision as to whether or not to grant.
Thank you so much, sir. There is another question. The first part of this new question is actually what was I was pondering about it, and thank God someone just asked that question from Udoma. You can just look at it. With respect to states that are not so developed, that probably can't, they don't have the resources, as it were, so what happens to them?
Okay. What happens is this. The ISA grants the contracts. However, there is a kind of what you may call a reservation for developing states. So there are areas kind of reserved for developing states. Now, if a contractor comes, usually they will identify an area that they want to be awarded. So if they identify an area, do exploration, when it comes to exploitation, the ISA will not award them the entire area for exploitation. So the ISA will award them only a part of that area. Then the other part will be reserved for developing states. So they devise that to help developing states, because a developed state comes in, gets a contract or sponsors a party, they get a contract, exploration, and then move into exploitation. During exploration, they would have made a lot of discoveries in the entire area that they were awarded. So when it comes to exploitation, they are not given the entire area. So a part of it is reserved. And that part of it will then subsequently be awarded to developing country-sponsored contractors. So it makes it easier for them because there's already a lot of knowledge about the prospectivity of this area that is carved out. So that is one way that they try to ensure that all states benefits equitably. I mean, it cannot be perfect equity. That would not be possible. But what is important is that there are mechanisms to help in that area. I don't know whether I have helped in my response.
Thank you.
So it prevents monopoly, kind of. It prevents monopoly.
Okay.
Just say.
I think there is a second follow-up question there. What, if possible, would like to know what reforms you would suggest to enhance fair and responsible governance. Still talking about the governance with respect to the common heritage of mankind by ISA.
Yeah, I thought I covered that. I mean, the regulations are still being negotiated, so nothing yet is there. What we have in place are exploration regulations. It is based on that exploration regulation that contracts have been awarded. But a lot of companies have indicated that they are ready to go into mining. But in the absence of an exploitation regulations, they may not be awarded a mining contract. However, for those who are familiar with what is going on there is what is called a 2-year rule, where if a state party can trigger the application of this 2-year rule for the negotiations to be accelerated. And if they are not accelerated and completed within 2 years, then a contractor may come forward to say, I need a mining contract. And the ISA would be required to, may be required to consider the application for mining and decide whether or not to grant. A country triggered the 2-year rule, was it 2 or 3 years ago? A Pacific Island nation, Nauru, who has a sponsored contractor. So they triggered the 2-year rule to accelerate the negotiations. Actually, more than 2 years have passed since then, but it has also helped in moving things forward more rapidly. COVID didn't help matters because I think one of the sessions was cancelled and there was remote session which wasn't that effective. So COVID delayed a lot of stuff. But things have picked up again. In March, there'll be a session in March, we'll be there, and then again in July. Hopefully it will be completed in July, but if not, maybe March next year.